What happens if a retailer is faced with the recall of a regulated tobacco product? We'll introduce you to tobacco product recalls in this edition of FDA's Tobacco Compliance Webinars. Welcome to this edition of FDA's Tobacco Compliance Webinars, education and information for retailers and small businesses, sponsored by the U.S. Food and Drug Administration and the Center for Tobacco Products. I'm Christina Peters. Thank you for joining us. Today, we will provide an introduction to recalls and some recommended practices for conducting a recall. Specifically, we will discuss FDA's recall authority, what constitutes a recall, the different recall classifications, how to be prepared for a recall, and the recall process. You will notice that some of our slides have reference boxes with links to relevant regulations and documents that can be found on FDA's websites. We encourage you to review those materials in addition to today's webinar. A recall is a firm's removal or correction of a marketed product that FDA considers to be in violation of the Federal Food, Drug, and Cosmetic Act, and against which FDA would initiate legal action. An example of such a legal action is a seizure of a tobacco product contaminated with mold, which would be adulterated under the Act. Recalls can be either mandatory or voluntary. FDA has the power to mandate recalls of tobacco products in the limited circumstances listed on this slide. If FDA orders a recall, the agency will issue a written order to the firm to recall. The order will include the product, lots, serial numbers, etc., to be recalled and provide a time frame for the firm's reply. For mandatory recalls, the recalling firm will have an opportunity for a hearing to challenge the recall order. A recall may be initiated by a firm at any time. A firm may also voluntarily decide to recall a product if FDA determines that the product violates the law and requests a recall. Recalls are most often initiated by firms such as manufacturers or distributors, either voluntarily when they determine that a tobacco product is misbranded or adulterated, or following an FDA request. FDA may request a recall when it appears that the distributed product presents a risk of illness or injury or gross consumer deception. FDA action is necessary to protect the public health, and the firm has not initiated the recall on its own. FDA requested recalls are usually reserved for urgent situations such as Class 1 recalls. We will explain recall classifications later in the webinar. Not all product removals and corrections meet FDA's definition of a recall. Although 21 CFR Part 7 does not define removal, in 21 CFR 806.2, the device regulations state that a removal means the physical removal of a device from its point of use to some other location for repair, modification, adjustment, relabeling, destruction, or inspection. An example of a removal would be a distributor taking a product out of a market where it is not selling and moving it to a different market. A correction means repair or destruction without moving the product to another location. An example of a correction in the medical device context would be on-site servicing of an X-ray machine. Removals and corrections are only considered recalls if FDA considers the distributed product to be in violation of the Act, and FDA would initiate legal action. A stock recovery is not a recall. It is a firm's removal or correction of a product that has not been marketed or that has not left the direct control of a firm. A market withdrawal is also not a recall because the distributed product has a minor violation that would not be subject to FDA legal action. Once FDA receives information regarding the potential recall, FDA will determine if the action is a recall and, if so, classify the recall by assigning it a numerical designation. FDA will assign a classification to the recall based on the relative degree of health hazard presented by the product being recalled. Class 1 is the most serious recall classification, while Class 3 is the least serious. Once classified, information related to the recall will appear on FDA's website. FDA will provide notification on its website of each new recall. its classification, and whether it was firm-initiated or FDA-requested. It is critical for firms that have products in a distribution chain to be recall-ready to help minimize public exposure to products that may be hazardous or otherwise in violation of the FD&C Act and other laws administered by FDA. The following are general actions that can be taken in order to be prepared for a recall. The firm can identify appropriate personnel. Specific employees can be assigned for recall-related responsibilities and possess the authority to take the steps necessary to implement a product recall. Personnel can be trained on their recall responsibilities. A recall communications plan can be established. Such a plan can address internal communications, communications with FDA, and communications to direct accounts or the public if a voluntary recall is deemed necessary. A firm can use product coding. Product coding may help a recalling firm accurately define and limit the scope of the recall effort. Because product coding facilitates a correct accounting of affected product, it may reduce the need to further expand a recall. Distribution records that are maintained can allow you to identify the consignees that received the recalled product. So what can a firm do if there's a problem with a distributed product? Firms should first identify the problem. As appropriate, a firm can implement procedures to identify potential problems with a distributed product. A potential problem is anything that indicates a product is violative, defective, or harmful to the public health. The firm should also investigate the problem. Qualified individuals can conduct a prompt investigation to assess potential risks. The firm should then make decisions and take action. The firm's procedures can assign responsibility and describe the steps to ensure that decisions are made to control defective and potentially harmful products in a timely manner. We encourage the firm to consult with FDA regarding any product problem, even while its own investigation is ongoing. Generally, there are 5 major steps in the recall process. We will discuss these steps in further detail in the following slides. The initiation of a recall and initial notification to FDA. The determination by FDA that the action is a recall and classification of that recall. The release of recall communications, including any public notification or public warning regarding the recall. The monitoring and auditing of the recall, and FDA's termination of the recall. FDA recommends that firms prepare and maintain written recall initiation procedures. These procedures help to minimize delays created by uncertainty as to the appropriate actions to take when a decision is made to initiate a recall. They also help ensure that necessary actions are not overlooked and may minimize the disruptive effect a recall can have on a firm's business. A firm's written recall initiation procedures should assign responsibilities and describe the steps to initiate a recall. Steps might include developing a recall strategy and notifying direct accounts about the product being recalled, including what should be done with respect to the recalled product. When notifying direct accounts, it is important to provide detailed instructions on how they can respond to you, as well as instructions for the appropriate disposition of recalled products. When appropriate, the public should be notified about any potentially violative product that presents a serious hazard to health. A firm's written recall initiation procedures should also contain information regarding notifying the FDA of the recall. FDA may request that the following information be provided when initiating a recall: the identity of the product involved, the reason for the recall, and the date and circumstances under which the product deficiency or possible deficiency was discovered. An evaluation of the risk associated with the deficiency or possible deficiency. Reports of any injuries or adverse events, either reported to the firm or known to the firm. The total amount of any potentially violative products produced, the time span of the production, and the total amount of such products estimated to be in distribution channels. Detailed distribution information, including the number of direct accounts and, where necessary, the identity of the direct accounts. A proposed recall strategy for conducting the recall. On the next slide, we explain what information can be in a recall strategy. Firms can also include a copy of the firm's public notification or recall communication if any has issued, or a proposed communication if none has issued. Lastly, it is helpful if firms make sure to include the name and contact information for the firm official with whom FDA will be communicating during the recall. As mentioned in the previous slide, a firm's recall strategy is one of the items that generally is included when a firm submits recall information to FDA. But what is a recall strategy? A firm's recall strategy is a planned, specific course of action to be taken in conducting a recall, which addresses the depth of a recall. That is, will the recall be performed at the consumer level, the intermediate wholesaler level, or the retailer level? The recall strategy can also address the need for public warnings and methods to be used for and the level of effectiveness checks for the recall that will be conducted. I will discuss effectiveness checks in greater detail in later slides. An effective recall strategy often takes into account the results of a health hazard evaluation, the ease of identifying the affected products, the degree to which the product's deficiency is obvious to the consumer, and the degree to which the product remains unused in the marketplace. FDA will review the information that was submitted by the firm to assist with the recall. First, FDA will determine whether the action meets the definition of a recall and conduct a health hazard evaluation. FDA will then advise the firm of the recall classification and recommend any changes to the firm's recall strategy. It is important to note that firms do not need to delay the initiation of a recall pending FDA review of the information the firm has submitted. In general, the recalling firm is responsible for promptly notifying each of its affected direct accounts about the recall. These notifications are known as recall communications. It is helpful if recall communications contain the following elements. They are brief and to the point. They identify the product, size, lot numbers, codes, or serial numbers, and any other information needed to accurately identify the product. The recall communications explain the reason for the recall and the hazard involved. They provide instructions on what should be done with the recalled product and provide a means for the recipient of the communication to report to the recalling firm whether it has any of the product. Follow-up communications are generally sent to those who fail to respond to the initial recall communication. The purpose of a public warning is to alert the public that a product being recalled presents a serious health hazard. Public warnings are reserved for urgent situations where other means of preventing use of the recalled product appear inadequate. In situations where the product may pose a significant health hazard and recalled product is in the hands of consumers, a press release issued by the firm is usually appropriate. Public warnings can be disseminated through general or specialized news media. Some examples are professional or trade press, or to specific segments of the population such as consumers, retailers, physicians, and hospitals. FDA generally gives firms the first opportunity to prepare and issue public warnings during recalls. As mentioned previously, whether a public warning is needed and how it will be issued is generally addressed in a firm's recall strategy. FDA reviews and comments on the recall strategies, including any public warnings developed by firms. Firms can include any drafted public warnings as part of their submission of the recall strategy to the extent that it does not delay strategy development or recall initiation. Issuance of a press release generally is the highest priority and is usually issued promptly. Firms generally consult with their FDA recall coordinator before issuing a press release whenever possible. But in situations that warrant an immediate warning, firms may choose to issue public warnings without FDA's review. FDA may supplement that warning with its own public statement if necessary. When FDA believes that a public warning is appropriate and the recalling firm does not include one in its initial recall strategy, FDA will generally request one from the recalling firm. FDA may issue public warnings in a variety of forms, including but not limited to press releases, emails, and web and social media postings. In situations where the product may pose a significant health hazard and the recalled product is in the hands of consumers, FDA may also issue a press release and post the document to FDA's website. FDA may also issue a press release if the firm-initiated press release is not adequate. FDA may prepare and issue public warnings on its own initiative. This may occur, for instance, when the public needs immediate warning concerning a product and the firm has not issued a public warning or a firm's public warning is deficient. FDA will ordinarily work with the recalling firm to ensure the factual accuracy of a public warning. FDA is not required to contact the firm before issuing a public warning or allow its review of the proposed statement. If a firm issues a public warning that is deficient in any respect, FDA may supplement or correct that warning with its own public warning. If a firm's public warning is not reasonably likely to be adequately received by the target audience, FDA may ask the firm to reissue its public warning and/or FDA may issue its own public warning. Additionally, FDA may publicly issue information that may address outstanding questions about the nature of the incident or the agency's actions. The purpose of a public warning is to alert the public that a product being recalled presents a serious hazard to health. As such, a public warning generally includes information to help identify the recalled product. Such information could include images, product codes such as lot numbers, expiration dates, and serial numbers, packaging information, or brand names. Public warnings also generally include the geographic areas and dates of distribution of the product, a thorough description of the product defect, and any health hazard involved, and reasons for the recall. Reasons for the recall could include product testing, environmental sampling, consumer complaints, or other reasons. Public warnings also generally include the name and contact information for the recalling firm, instructions to consumers or users, the number and nature of any illnesses, injuries, or complaints associated with the product, and a description of common symptoms of any illness of concern. The headline of the public warning generally includes the brand name, type of product, and the hazard prompting the recall. For example, XYZ chocolate chip cookies recalled for potential salmonella contamination. In some cases, it may also be necessary to include the recalling firm's supply chain relationships in order to alert the public of the product being recalled. When possible, FDA encourages firms to provide specifics about firms it sold product to in order to help people better identify and avoid recalled product. Generally, public warnings do not contain content that detracts from or defeats the purpose of the warning. Brief and succinct warnings are generally better at informing consumers of a product hazard and helping consumers understand the importance of avoiding the product. On the other hand, messages that cloud or lengthen a warning may distract a consumer and generally are avoided. Firms generally do not promote the qualities of the product being recalled, other products sold by the firm, or the firm in general as part of a public warning. Phrases such as an abundance of caution that can be seen as trying to minimize the hazard generally are not used. For example, when illnesses or injury have resulted, or when there are positive results for pathogens associated with the finished product or ingredients. Recall status reports are requested by FDA to assess the progress of the recall. The frequency of the reports will be determined by the relative urgency of the recall and will be specified by FDA. Generally, the reporting interval is between 2 and 4 weeks. The recall status reports generally contain the date and method of recall notification, the number of consignees that were notified of the recall and that responded to the recall, the number of consignees that were unresponsive to the recall notification, the amount of product returned by each consignee or products accounted for, the number and result of effectiveness checks that were conducted, and the estimated time frame for completion of the recall. Once FDA terminates the recall status reports will be discontinued. It is generally the recalling firm's responsibility to ensure that the recall is effective. In some cases, FDA will assist in this task where necessary and appropriate. Firms should consider doing effectiveness checks. The effectiveness check is a firm's means of evaluating whether a recall was effective. It is used to verify that the recall notification letter was received by the customer, that the customer read and understood the letter and followed the recall instructions. The effectiveness check also verifies if the recall reached the appropriate level in the distribution chain. FDA may selectively conduct audit checks separately from the firm's recall efforts to assess the adequacy of the recall. A guide on conducting recall effectiveness checks can be found in FDA's Regulatory Procedures Manual, August 2018, Attachment H, Methods for Conducting Recall Effectiveness Checks. A recall will be terminated when FDA determines, in accordance with the firm's recall strategy, that all reasonable efforts have been made to remove or correct the product, and when it is reasonable to assume that the product has been removed and proper disposition has been made. FDA will provide written notification to the firm that the recall has been terminated. Firms may also request termination of their recall by submitting a written request to FDA stating that the recall is effective and including the most current recall status report and description of the disposition of the recalled product. On this slide, you can see references which may assist you in learning more about recalls, including regulations, guidance, FDA's Regulatory Procedures Manual, and FDA's Investigations Operations Manual. We have some great resources for you on our website, and we encourage you to review these materials. Please also check our website often for updates and sign up for the Center's CTP News and CTP Connect email services. If you have any questions regarding the topics discussed in this webinar, please contact askctp@fda.hhs.gov or 1-877-287-1373. In addition, the Office of Small Business Assistance provides technical and other non-financial assistance to support small tobacco businesses in complying with the FD&C Act. The Office of Small Business Assistance can be contacted by email at smallbiz.tobacco@fda.hhs.gov. Thank you for watching this presentation brought to you by the Center for Tobacco Products, whose mission is to protect our kids and the nation's health from the dangers of tobacco.